Ladies and gentlemen, a warm welcome to all of you. When I was born in 1980, Justice Y.V. Chandrachud was the Chief Justice of India. 44 years later, I'm sitting next to his son, who has just demitted office as the 50th Chief Justice of India. What a phenomenal achievement. What a phenomenal achievement. Like father, like son. And how did he achieve this? Was he standing next to his father's chair in the Supreme Court of India? The father rose, made his son sit, put the crown on his head, and made him, said, henceforth you shall be the Chief Justice of India. No. That doesn't happen in independent India. It might have happened in British India. Dynasty, or dynastic things don't happen now. He was pursuing his master's in law in the prestigious Harvard Law School when his father was the Chief Justice of India here. He obtained his master's in 1983, his doctorate in law, again from the Harvard Law School in 1986. After his father demitted office in 1985, he came back to India, started his practice at the Bombay High Court and the Supreme Court, and then he got designated as a senior advocate in 1998, sir? Yes, 1998. Then he got elevated as a judge of the Bombay High Court in 2000, in the year 2000. 13 years he was a judge. In 2013, he was made the Chief Justice of Allahabad High Court. 3 years he was there. In 2016, he became a judge of the Supreme Court. 6 years he was there. In November 2022, he occupied the topmost judicial office in the country as the Chief Justice of India and completed his 2-year tenure in November 2024. It's an honor to be with him here. Now, all this speaks of his intellectual abilities. And I don't know how many of you know about his charming personality. I must say this. So one of my colleagues, when she knew that I'm going to be in a discussion with him, she told me, sir, please tell him that he looks like Shah Rukh Khan. He may be 65, but he looks 45. My son saw him on television, 12-year-old boy, and then says, how come he's so young? I asked him what? He said, Chief Justices would generally be old, aged people, haggard, right? And he's dashing. And one more advice he gave me was, he saw 2 of his interviews. In one of the interviews, he was wearing a pullover sweater, and he looked nice. And so he told me, when you meet him, tell him that he looks good in casuals, more than formals. So that is the kind of personality we have here, and I'm happy we shall begin this conversation now. Sir.
Thank you. Thank you very much, Imran.
Welcome, sir.
Wonderful words of welcome.
So, appointment of judges to the higher judiciary has always remained a challenge. Jurists often say that those who deserve to be judges do not want to be judges, and those who want to be judges do not deserve to be judges. Having been a part of the collegium in the Bombay High Court, in the Allahabad High Court, and again in the Supreme Court too, how difficult did you find to convince good lawyers to accept judgeship?
At one time, accepting the call of office to the higher judiciary, I presume you're talking about the high courts and
Of
the
course,
Supreme
yes.
Court, was always considered a matter of honor. So when I became a judge and when the Chief Justice called you and requested you to become a judge of the court, no was never an answer, because it was an answer to a higher calling, namely to serve the nation for public service. Things have gradually changed. And I'm glad you asked me about my experience ranging from Mumbai to Allahabad and then to Delhi. What's increasingly happening is that good lawyers are just not willing to accept judgeship, particularly in cities which are, the commercial cities like Mumbai, and this is spreading all across the country for a variety of reasons. I think part of the reason is, of course, the wide disparity between what a lawyer makes in the course of a day at work and practice. But I think that's only part of the reason, because somebody who accepts public office never does it because of the emoluments which you get, or because of the trappings of the office. Like when I became a judge, you had those flashing red lights in your car. Nobody really becomes a judge because of that. You become a judge because of an inner calling that you want to be of service to the community, to society, to be part of the transformation of society. But apart from the tremendous disparity, and this is something which you can't discount, for the reason that judges at the High Court retire at the age of 62, the Supreme Court at 65. At 62, you're at the peak of your capacity, and I dare say at 65, when you're suddenly told that you can't work anymore in the court. So more and more people are then asking themselves about what they would do after they retire. One, you can't go back to the bar, and there's such a huge disparity. I mean, just the economics of it doesn't work well. So if we truly want to safeguard democracy, then this is a price which you have to pay, namely of having judges who are going to be paid good salaries, both when they are in office and after retirement, because how a judge lives after retirement determines the independence of the judiciary when the judges are in office. You don't want to have judges who are going to look at post-retirement assignments. But apart from that, there are other reasons. I mean, whenever I spoke to lawyers, it was a Herculean task persuading them to become judges of the High Court, particularly in Bombay. And they would say that, Judge, it's not just a question of the difference in emoluments, because we don't have a fancy lifestyle, we don't have crazy ideas about living. But we have very strong reservations on two issues. One, the uncertainty in a judicial career. You really don't know where you would be, say, 10 years or 12 years or 15 years down the line. That uncertainty is there in any job. And uncertainty is no ground really, therefore, to spurn a job. But apart from that, a lot of lawyers would say that, well, I'm just not willing to accept the element of distrust and the kind of scrutiny that goes into every little aspect of your personal life. It is as if that when you accept that you're going to become a judge, you're laid open to almost anybody saying whatever they want to say about a judge to be. So, that's one thing which we really need to think about, because just as there is legitimately a plea for transparency in all aspects of our public life, and I, for one, I support that plea for transparency, and that's why I, promoted live streaming of our court proceedings. At the same time, we need to ask that we have to draw the line at a point where the evil which you are trying to curb would not be dealt with by your answers, and in fact, good people would just not be willing to accept the call of office. In the tier 2 cities, if I may, with great respect, call them, they are not tier 2 in the sense of the intellect of the people. In the hinterland, for instance, when I went as Chief Justice to the Allahabad High Court, it was less of a problem, because judgeship does still command a certain degree of social respectability, community values, community status. That is not so much now in larger cities like Mumbai, Delhi, Bangalore, Chennai, Kolkata. You see so many more young people saying, sorry, I just don't want to become a judge. The final reason I think why people don't want to become judges is, the constriction of lifestyle. The first thing that happens to you when you become a judge, you are completely isolated. You're isolated from your friends. You're isolated from the life which you lived as a lawyer. There are things which necessarily you can't say in public because of the constraints of office, the discipline of the office, and people are just not willing to accept that change, which is a very significant change. And it's not a change only so long as you are a judge. It still affects you even after you lay down office.
My second question would be on, a layman often asks, now for example, we take the Madras High Court. A sanitary worker has to be appointed there. A notification is issued. There is a written test. There is a practical test where they have to clean the toilets and show how well they can clean. And then they sit for an interview. When so much is being scrutinized to appoint a sanitary worker, how come a judge of a high court gets appointed just like that, despite it being a constitutional post? A layman fails to understand that his lawyer, whom he was meeting till yesterday, suddenly becomes a judge just because the collegium thinks that X, Y, or Z is capable of holding judgeship. What would be your answer?
Now, 2/3 of the judges in the High Court are drawn from the bar. This is a convention. 1/3 of the judges are drawn from the district judiciary. The judges who come from the district judiciary are again drawn from those who entered judicial service after facing a competitive examination. And interestingly, almost in most states now, the number of women entering the district judiciary is way in excess of 50%, some states up to 70%. That's not your question though, so I'll not go into that. So there is a threshold assessment which takes place of all district judges at the point of entry. A junior civil judge becomes a senior civil judge, an additional district and sessions judge. There's a lateral entry into the district judiciary when you appoint directly recruited district judges, that you can become a district judge with a certain number of years of service, again at which stage there is an examination. There is a continuous assessment of your ACRs, the annual confidential reports, the quality of your judgments. So the district judiciary, which eventually moves as a career progression into the High Court, is therefore subject to continuous assessment right at the threshold. Even when a district judge is appointed to the High Court, there is an assessment. There's an assessment of their judgments independently by a judgment assessment committee of senior judges of the High Court outside the collegium. You look at any complaints against them. There is an assessment of their annual service record, so on and so forth. Now you must understand, now when it comes to appointing lawyers to the High Court, the minimum age for recruitment to the High Court is 45. We generally don't appoint people anymore below 45. I was asked when I was 38 and I became a judge when I was 40. But the ordinary rule is 45. Now the question is this, at the age of 45 when you are appointing a lawyer to be a judge of the High Court, are you going to ask them to sit for a test on the basic principles of civil law or criminal procedure code? Are you going to ask, say, a person who's going to become a CEO of a large company in corporate India at the age of 45 or 47 to become a CEO, hey, wait a minute, we're going to get you back to what you learned in management school and ask you to appear for a written examination? It doesn't work that way. In fact, we would always joke that so many people at the age of 45 or 50, if you ask them to appear for an examination, they'll probably flunk it. Because that's not your life. By the time you're 45 or 50, what you have is in terms of your experience, your court craft, your knowledge in the practical application of law. But I want to really clarify this, that the assumption that lawyers who are appointed as judges of the High Court do not face an assessment is again wrong. They are subject to very careful assessment. One, the collegium which recommends a lawyer for appointment to the High Court has the benefit of hearing that lawyer day in and day out, and not over one case or two cases, for years. The Chief Justice may be a very new Chief Justice drawn from outside the state, but typically your collegial judges have seen that lawyer evolve over a period of time. The appointment process is vetted by the state governments in the states. It is vetted by the union government, where a very detailed analysis of antecedents and character is made by the Intelligence Bureau and the Ministry of Home Affairs. It is also vetted by judges of the Supreme Court drawn from that High Court. So if we are making an appointment to the Madras High Court, judges of the Supreme Court who are drawn from Madras, not originally necessarily from Madras, but even people who moved into Madras as Chief Justice, their opinions would be sought. So the assessment to appointment of judges in the High Court does take place, but it has to be an assessment commensurate with a constitutional office which you are going to hold. For instance, when you appoint a chief minister in a state, I'm not saying that there is a parallel. That's a political office. This is a constitutional judicial office. Are you going to ask a chief minister, you better appear for these questions, on governance? No, that's not the way it works. It doesn't work in a political democracy. Does it work the same way when you appoint a governor? Will you appoint, when you appoint the president of India? Therefore, these are constitutional offices. The assessment for appointment of judges of the High Courts has to be there, and it does take place. But it's very different from the first threshold level of assessment. You rightly gave the example of a sanitation worker. Likewise, when we appoint judges who are junior civil judges in the district judiciary, they are made to face the whole gamut of examinations. They have to go through, testing for their knowledge of substantive law, their interviews, and they go through the whole process of appointment. Likewise for the High Court. When it comes to the Supreme Court, last part of your question, appointments to the Supreme Court are generally made from the pool of High Court judges, High Court Chief Justices and High Court judges. At that point of time, the critical ingredient is the quality of work which is done by a High Court judge. Every single day, every judge of the Supreme Court, particularly Mondays and Fridays, has anywhere from 60 to 80 cases to handle. So you're reading 60 to 80 judgments drawn from the judges of the High Court. In the Collegium of the Supreme Court, when we are discussing names for appointment to the Supreme Court, at least I made it a policy to get random judgments of the High Court judges who are under consideration, circulate them on a pen drive to all members of the Collegium, so that everyone has studied those judgments. You've all read the judgments of Judge X or Judge Y, but the importance of that is when you're sitting as a Collegium, you read the same judgments over and again. Otherwise, you know, as a judge, I would be reading very different judgment from what you would be reading as another judge as part of the Collegium. So there is this assessment. I'm not saying that it's perfect, but to say that there is no assessment wouldn't be correct.
Now, coming to this Collegium, for example, right now in Madras High Court, we have 10 vacancies. 75 is the sanction strength, 65 is the working strength. 12 vacancies are going to fall this year. So 22 vacancies are there. The Collegium has to recommend names. Now, if I say that there can be a quid pro quo between the Collegium members and the state government, saying that I will recommend 5 names, each of you members recommend 5 names, I will not object to the names you recommend, you will not object to the names I recommend. Can you say for sure that this quid pro quo cannot happen in the Collegium system?
Are you saying for a moment that the quid pro quo is with the government or between the members of the Collegium?
Between the members of the Collegium and the government.
All right. In other words, what you are asking me really is this. Can you say with certainty that there is no imperfection in the system? I mean, I don't think in any system of democratic government or governance that you can say that any system is 100% perfect. And I don't think I can venture to make that assumption or even that statement. But to say that there are imperfections in any system is one thing. The answer to it is not to jettison the system. Because what alternative do you have? And we'll probably be discussing as we go along, you know, what the alternatives are. So the question is, do you have a better alternative? But to come directly to your question, and assuming, let me for a moment assume that there is an element of quid pro quo in a given case, because, you know, 3 members of the High Court are sitting together as a collegial team. They're obviously discussing the merits of people who are being appointed. They bear in mind a whole host of considerations, appointing people from diversified backgrounds, from gender, from the perspective of gender, having more women, having more people from the marginalized groups in society, the scheduled castes, the scheduled tribes, the backward classes, to have people from different segments of the community, particularly in a society which is so multi-religious, multicultural, and plural as our society. But assuming that there is this element of not give and take, but this element of discussion, and there is this element, according to you, there possibly, how do you rule out a quid pro quo with the government? The answer to it is that the scrutiny does not end at that level. In fact, you find that there's another level of scrutiny which takes place in the Supreme Court Collegium. So in the Supreme Court Collegium, the first 3 judges who decide on whether a name which has been proposed by the High Court should or should not be accepted, they are one step removed from it. They would make their own inquiries. They have their own inputs. They have inputs from their own colleagues in the Supreme Court. They have inputs from the government. They have inputs from a wide variety of sources. For instance, the Collegium in the Supreme Court even can consult a senior member of the bar or more than one senior member of the bar from that particular state. So you're constantly taking inputs from various levels. And if you find that there was some quid pro quo which led to a person who is not deserving to be recommended, that additional level of scrutiny or assessment or the multi-layered assessment then adds some degree of assurance that, you know, these kind of things are overall evened out. But if you still ask me, is the system perfect? How can I say with any measure of confidence that the system is perfect? I mean, in any system of democratic governance, every system which you conceive of can't really be perfect either conceptually or for the simple reason that it's manned by human beings. But the effort must always be to reduce the imperfections, either by recourse to some transparency or objective norms, so on and so forth.
Now coming to social justice. When you were the Chief Justice of India, you made sure that there was inclusivity. And you even made sure that the collegium recommendations had explicitly mentioned why you were recommending a particular person to become a judge and what is his social background and why we require such people in the bench. Despite all that, still inclusivity of women, the physically challenged, in the judiciary is still a debated topic. Would you like to elaborate on that?
Yeah, of course. I think it's very crucial. It's a very valid concern that you have raised. Now, when you talk again, we are talking again of the high courts and the Supreme Court. As I said, insofar as the district judiciary is concerned, the fascinating part about the evolving nature of India as a nation, as a society, is the fact that over 50% of women are entering the judiciary at the lowest levels, which means it suggests two things. That when you give women a level playing field and an equal opportunity, women are not just doing as well as men, but they are doing much, much better than the men are doing. And by and large, if you talk to the young audience today here, in the national law schools, or why just the national law schools? Even the non-national law universities, you find over 50% of the inflow into the first year LLB class is of women. So that's happening across India now, that you have more and more women entering into the law schools. Question is, how do we ensure that these women who enter law schools, they don't sort of fall by the wayside in the profession? Because all said and done, the legal profession even today is terribly patriarchal. Women have far greater responsibilities in a social context than men do. They take the burden of childbearing, child rearing. And therefore you find that a lot of women really drop out from the bar as a result of the conditions of work. So Imran, your question on why don't we have more women is also to be answered in the context of how our profession is structured. How do we ensure that the legal profession, which is not just a judicial responsibility, is the responsibility of each one of us in society, how do we ensure that the legal profession itself is not a gendered space, that it is an equal opportunity space? And we can do that by making sure that, recruitment to chambers of lawyers is more meritorious. That's why the law firms have been very successful, because recruitment to law firms has been merit-based. It doesn't, proceed on the basis of the old boys network. That change is still to take place, though it is taking place gradually. Now, in the higher judiciary, now take the case of the Supreme Court. I was always asked this. Why is it that you have only, say, 3 women judges in the Supreme Court? And I always say that, look, the state of the Supreme Court today, in terms of the recruitment of women, reflects the state of the high courts 15 years ago, when those women who are now going to be part of the pool for appointment of the Supreme Court were appointed as judges of the High Court. And that necessarily reflects the pool of legal talent in the legal profession 20 years before that, when they joined the profession. Things are changing now, as you find more and more women, being extremely successful as lawyers. There are lot of things which, institutions can do as well. For instance, in the 75 years after independence, between 1947, actually from 1950 to when the Supreme Court was set up, between 1950 and 2024, all of 13 women were designated as senior counsel in the Supreme Court. Just 13 in close to 75 years. Last February, in one lot, we designated 12 women as senior counsel. And we followed that up in August with another 10 women. So as institution builders, judges are not just adjudicators, you're also an institution builder. So you need to, make a conscious effort to allow for women to have more positions of responsibility in the legal profession. You spoke about the disabled, people who have physical disability. There was a judgment of the Supreme Court itself, which had said that, somebody who is blind, who is visually challenged, cannot fulfill the role of a judge. I overruled that judgment. I overruled the judgment sitting in a larger bench of 3 and said, well, visual disability has nothing to do with your ability to work as a judge. And that has again been affirmed recently, just last week, by another bench of the Supreme Court. In fact, one of my law clerks, when I was a judge of the Supreme Court, was a blind Rhodes Scholar. And he was pursuing his master's at Oxford and called me up and said, I want to come and clerk for you. So I said, why on earth would you give up a Rhodes Scholarship and come to work with a judge of the Supreme Court? Because he says, that's my social conscience. So he came and worked with me, and he told me a lot of things which we could do to make law and life easier for the visually challenged. For instance, we had, just to give you a little bit of this, anybody who is interested in technology, we would have visual captures. Now, somebody who is blind cannot access a visual capture on the website of any public website. So we first changed our visual capture into an audio capture. Files were digitized. They were digitized in such a way that they were OCR enabled. So somebody with a visual disability could read those files. Technology has been a great enabler. So I think, but for the disabled, people suffering from disability, a lot more has to be done in our system. Last year, we had this young woman lawyer. I can share her name because she wouldn't want it to be private. Her name is Sarah Suni, and Sarah has she has she's hearing impaired and she's speech impaired. And she pointed out to me that, look, I'm a lawyer. I want to argue my cases. But how will I argue my cases in the Supreme Court if there's no sign language translation facility? So for the first time, we introduced sign language translators, interpreters, in the Supreme Court. So things like that, during my tenure as the Chief Justice, we carried out an accessibility audit of the premises of the Supreme Court. The committee was chaired by Justice Ravindra Bhatt, who was my colleague, and we had a whole lot of civil society domain experts. And they went to every little space in the Supreme Court, including toilets. Are the toilets accessible to the visually, to the physically disabled or the physically challenged citizens? They came out with a report on what changes we need to do in the infrastructure of the Supreme Court. And I wrote across to all the high courts that please start this process in your courts as well, so that more disabled people can come to... Incidentally, we also set up the Mitti Cafe in the Supreme Court. And the Mitti Cafe is run by this very young woman, and everyone who works in Mitti Cafe is disabled. So everybody from somebody who mans the cashier to somebody who serves you there is physically challenged.
That's fantastic.
And the President of India came to the Supreme Court for the installation of Dr. Ambedkar's statue. So when we were walking back from the installation ceremony to the unveiling ceremony to my chamber, I asked the Honorable President, I said, ma'am, would you like to see Mitti Cafe, which is a cafe which is run exclusively by disabled? And she said, I would love to go. So, she pushed aside all her security and she walked into the cafe. She sat on one of the tables in the cafe, talked to everybody in the cafe. But these are huge learning experiences, and these are symbols that, we are trying to become more inclusive. The Delhi High Court set it up. I'm told the Gujarat High Court has set it up. Rashtrapati Bhavan has a Mitti Cafe now, a cafe which is run by. So more and more of our public spaces, whether it's in the newspapers, it's in corporate India, they have to have. We must allow for greater footage for the physically disabled. Just 2 days back, last story. 2 days back, a mother wrote to me and she came with her daughter. Her daughter stood first in the CBSE and in the higher secondary. She cleared the IIT JEE, but she only qualified in IIT Delhi and Mumbai for chemical engineering. The mother said, what will she do with chemical engineering? I want her to become a computer specialist, an IT specialist. So they went to Kanpur. She went with her daughter, settled in Kanpur. The girl passed her education in IIT Kanpur. Has now got a job in Microsoft in Hyderabad.
Wow.
So these are the sort of things, and she suffers from spinal muscular atrophy. So she's in a wheelchair, like two of our own two daughters whom we have adopted. So in that sense, therefore, so much is a product of what judges do, and so much is something which is much beyond just the role of judges. I think it's all about, how we as members of civil society try and improve.
Great, great. So what DYCJ is telling the women here is that all of you will be in the bench after 10, 15 years. Men will need reservation. All right. Okay.
Yes, of the South African Constitutional Court. He was he's a blind judge and did brilliantly, actually.
So I'll move on to my next question. National Judicial Commission. So we had this National Judicial Commission Act and the Supreme Court, your Supreme Court struck it down. Now,
your Supreme Court as well, it's everybody else's Supreme Court.
So what do you think right now should the Parliament do? Should they bring in another law? Or do you think the collegium system should stay on forever?
Well, let me begin by saying that, Parliament doesn't need our advice. Obviously, they know what they can do. Even if a judgment of the Supreme Court strikes down a legislation, or in this case, a constitutional amendment, on the ground that it suffers from certain deficiencies, those deficiencies can be cured. And by enacting a new law or a new constitutional amendment which takes care of those deficiencies. Parliament can't say that a judgment of the Supreme Court is wrong, but they can certainly take away the deficiencies which have been pointed out by the Supreme Court. That's constitutional theory. But I really want to ask you, since this is more of a chat than an interview, I want to ask you this. If you want to replace, say, the collegium system with a new mantra or a new avatar of the National Judicial Appointments Commission, what is it that we as a society are trying to achieve? We must first define what our objectives are. If we define what our objectives are, we'll know what to do. What are those objectives? First, you must have judges who possess competence. In an increasingly complex world, when we have disputes, as India has been liberalized and the economy is liberalized, you have complex disputes on electricity, competition, insolvency. So you need domain experts as well. So you need competent people as judges. Among them, there should be domain experts. That's one. Second, you need people of integrity. Third, you need people who will preserve the tradition of judicial independence. That's the third thing the third parameter. Fourth, the character of the judiciary must broadly be representative of the character of society. Namely, just as Indian society is diverse, whether in terms of gender or sexual orientation or caste, marginalization, there has to be broad representation, particularly to regions, to communities, to castes. And fifth, there has to be a greater deal of representation, particularly to the marginalized and to the minorities. These are the 5 broad parameters. Now, if you're going to replace the collegium system by a new institution, I'll not label it on what you call, labels are really just a matter of, labeling, that's all. If you're going to replace the collegium by something else, the structural design or the constitutional design of that new institution must be such that these objectives which we have laid down, and I'm not saying that these are the only objectives, you may have other objectives, which I've just sort of missed probably in just, a spontaneous response, that these objectives will be better fulfilled by the new institution which we are creating. For instance, judicial independence has been one of the critical features of Indian democracy over the last 75 years, which really means that the government should not have a predominating voice in the selection of judges. So if you create a new institution by saying, oh, well, the collegium has these defects, now we'll have this particular institution, we'll have another National Judicial Appointments Commission. Do you want, merely because of the defects of the collegium, to create a new institution which will not answer those defects? Or how do you create the institution which you want to create, which will take care of those defects? Now, independence. Who selects the judges is critical. How will you ensure that the new institution which we are putting into place will result in a selecting body, which again is independent. Because the independence of the selected people is often determined. Why often? It is determined always by the independence of the selectors. How good your cricketers are depends on how good your selectors who select those cricketers are. Right? To give you a cricketing analogy, since IPL has started. So, the question is not just about, is the collegium going to continue forever, or should we have a National Judicial Appointments Commission? At a constitutional level, there's no bar at all. Parliament can always, take care of the defects which have been pointed out by the Supreme Court in the NJSC judgment. But my concern is broader, which is that any alternate institution which we create must be an institution which preserves our concerns as citizens in the legitimacy of the Indian judiciary, the credibility of the Indian judiciary, that it should be an institution which in that sense does not really multiply the problems instead of creating a better situation.
Now I'll come to the performance of judges. Pendency of cases has always been a concern for all of us. The numbers are growing up and up and up. And then we have hard-working judges, and then we have hardly working judges. Now, when it comes to the district judiciary, there is, as you said, that ACR, annual confidential report for every judge, where a portfolio judge, a high court judge, assesses the performance of the district judge. Do we have anything like that for permanent judges of the High Court or the Supreme Court?
No, we don't have an assessment of the work of a judge of the High Court by either the Chief Justice, nor is there an assessment in the terms of, in terms of grading or giving grades to the work which is done by a judge of the Supreme Court, by the Chief Justice or by the senior judges. We don't have it like that. Question which you asked me is a very legitimate question again. Shouldn't we really be imposing some parameters for assessing the quality of the work which is done by, say, judges in the High Court? Because you made that distinction between judges who work hard and judges who hardly work. Now, that's all right. That's great coffee table conversation. It's not exactly reflective of reality. But, Imran, how do you assess judges is again a very critical point. Should we assess judges, if we were to have an assessment, only by the number of cases which they disposed of? Now, if we go by purely volume-based parameters or quantum-based parameters, I can assure you that's the easiest thing in the world for a judge to dispose of, to show that you have disposed of 10,000 cases in a year. Pick out all the small cases, including the small applications which come, and say I've disposed of 100 cases today. On the other hand, a given judge may be, you have very distinguished lawyers and the senior advocates in the audience as well. You may have a judge who's dealing with an election petition. That election petition might take that judge 15 days to dispose of. A judge may be dealing with, say, a criminal appeal in a bomb blast case, where there may be like 100 witnesses, there may be multiple accused. These kind of cases take a lot of time. So the nature of the assessment must also factor in the quality of the work which the judge is doing. But yes, I do believe that, it's important for us to have some assessment of the quality of work which is done by judges without, again, impinging on the independence of the court. So the assessment must be by someone who does not have the power to affect the independence of that particular judge. Now, what kind of assessment should we have? As I said, it can't be a quantum-based or a quantity-based assessment. It has to factor in both quantity as well as the quality of the work which is being done by the judge. The greatest, ultimately, Imran, in a democracy, the greatest guarantee that you have to judicial performance is scrutiny by the public. The work which is done by a judge is constantly being assessed by the lawyers who are in front of that judge, the lawyers who sit in the court. I mean, suppose we are the two judges in a division bench and you have this big audience of lawyers in front of us sitting in the court.
I've become a judge.
They are watching every move. They are watching every order that you dictate. They are making a note of every observation of the judge. They are passing judgment on the judge every single moment of the day. That's the beauty of, an open court that we have. the reason why I also promoted, live, the video conferencing and live hearings being relayed on YouTube, and now we are, of course, going to our own cloud infrastructure, live streaming of court proceedings. I felt that there is a degree of accountability which then arises on the performance of a judge. When a judge knows that you are being live streamed, people at large want to know, are you sitting through the day, or do you just get up at 2 o'clock and run away and you're not available in court after that? People should also know why cases are adjourned. Do judges adjourn cases, or is it that lawyers are not ready to argue cases? So, greater transparency in judicial performance has its own safeguard for proper judicial behavior by a judge. Things like, how long have you kept a judgment pending? How many judgments does a judge have in arrears? These kind of disclosures, which the court must make as an institution, not an individual judge. An individual judge has no time to say that, well, I have 20 judgments pending, or I have 100 judgments pending. Sometimes the most hardworking judges are the ones who have the most judgments pending, because they have such a great turnover. But these disclosure requirements by the court, the Registrar General of the court, or a team in the court, should lay before the public these basic parameters. How many cases did the judge dispose of? 2, how many judgments has the judge written? 3, how much leave has the judge taken? So on and so forth. And I think that itself will provide a great deal of transparency to the process.
When I was sitting here in the morning, so many people came to me and said, hey, when you talk to Dr. Justice Chandrachud, ask him about the Delhi cash on fire, that fire, the Delhi High Court judges. Now, I will not go into the specific case as such. Corruption in judiciary. Quite a few former Chief Justices have conceded that there is corruption in judiciary. How do you think can this problem be dealt with?
Well, at the first, I think it's very important to understand whether it's at the level of the district judges, whether it's in the high courts or higher. What power does the court have as an institution to deal with cases involving corruption? Cases involving corruption in the district judiciary are dealt with on the disciplinary side by the high courts. The real deficiency which I have found in the whole process is that the judiciary does not have, in that sense, its own investigative arm. So if the conduct of a district judge is to be scrutinized, now if you're going to be terminating the services of a district judge or dismissing a district judge for corruption, you can't dismiss a district judge for corruption on the ground that the lawyers in the canteen were saying that this person is not a straightforward judge. You have to have concrete evidence of misdemeanor before you terminate a judge. Now, if that is so, there must be an independent fact-finding machinery which is available to the high courts. Typically, the high courts rely on their own officers from deputation who are brought from the district judiciary into the high court, who will then act as presenting officers. They are the fact gatherers. So you don't have a situation where the high courts have an independent fact-finding arm. And we don't want to rely on the police machinery, because the whole purpose of this is to maintain the independence of the judiciary. The moment you entrust this to the executive, that would again affect judicial independence. Likewise, suppose there is an issue of corruption in the high court. And as you rightly said and fairly said, we are not talking about a particular case, because the case you mentioned, it's being seized off by the Supreme Court, and they're dealing with it. So I don't want to cover the merits of the case. If there is a case where there's an allegation of corruption in the High Court, you have the memorandum of procedure, the in-house procedure. The in-house procedure mandates that what is to be done, the Chief Justice of India will call for a report from the Chief Justice of the High Court. Then, on the basis of that report, decide whether a committee of 3 judges, 1 Chief Justice and 2 other judges, will scrutinize the facts and the allegations, and thereafter make a report. I was once the chairman of a committee, which was called upon by the then Chief Justice of India to inquire into allegations of judicial misconduct by a judge of the High Court in those days. So we were 3 of us. Now, the deficiency which you have in the process is that neither the Chief Justice of India or the Collegium of the Supreme Court or the committee which is appointed by the Chief Justice of India for carrying out the in-house procedure has its own investigative arm. If you don't have your own investigative arm, you will necessarily have a deficiency of information, of evidence which can be used in that sense to bring errant judges to book. So in that sense, I think, there has to be a complete rethink on the procedure which we follow. And, there are only 2 or 3 courses of action open to the Chief Justice of India. The Chief Justice of India may transfer a judge. Now, it is always said that if a judge is errant, why are you just transferring that judge from High Court A to High Court B? Because that judge will continue to be errant in High Court B. But these are constitutionally, the only means which is open to the Chief Justice of India is either to transfer the judge or commence the in-house procedure. After the in-house procedure is complete, if you find that the judge has been held guilty of a misdemeanor, you then make a reference to the government of India, to the President of India, to start a process of impeachment.
But then, not a single judge in the country has ever been impeached.
You're right. The only judge whose case for impeachment came up for a full discussion in Parliament, that, as you know, ended in an inconclusive vote. Another judge resigned before the impeachment motion could be taken up. So that's also an indicator that our experience over the last 75 years suggests that impeachment by itself is extremely cumbersome. Impeachment as a process is extremely cumbersome. It is time consuming. You have to have a far more flexible and effective process of disciplining judges. I would even say that it should be a process in which some members of civil society should be associated with the inquiry. Again, who from civil society should be associated with the inquiry is also critical. Because again, you want an independent person, not someone whose position can be used to affect the judicial independence of a particular judge, merely because that judge had an inconvenient view in a sensitive case. Which means that you will have to again trust, say, the Chief Justice of India, or the 3 senior-most judges of the Supreme Court to nominate, in consultation with the union government, people from civil society, 2 members of civil society who could also bring a greater degree of confidence in the process. So I'm not sure that I have perfect answers for what you have asked, but these are some of the things which I think there has to be brainstorming in India, because the independence of the judiciary, the credibility of the judiciary, the moral credibility of the judiciary is too very important for us to take it lightly. It defines the very core of democracy. And therefore, I think there has to be a great deal of public debate in our legislatures, and across India to arrive at a better solution.
You have delivered numerous judgments. You are known as the dissenting judge always. So many. And then your judgments on permanent commissions in the Indian Army and in the Indian Navy for the women. What wonderful, fantastic judgments. They were celebrated internationally, actually. Despite all this, these judgments get overshadowed by the decisions you took in Ayodhya, abrogation of Article 370, and people are not happy with it. You have your own critics. Do you have something to tell your critics on this?
I can only say this. You never write as a judge to please or displease anybody. You decide a particular case based on where the balance of law and justice lies in that particular case. A judge never can be regarded as a left-leaning judge or a right-leaning judge or a center-leaning judge. You decide each case based on the merits of that particular case. And no judge writes either to please or to displease. You write true to your own conscience and to the call of constitutional conscience. People are entitled to critique what you write. And that's what democracy is all about, and that's what free speech is all about.
And since students are here, I'll end with a light-hearted question. We all want to take revenge against our fathers. When you are young, they keep shouting at you, yelling at you, telling you, don't do this, don't do that. You know how he took revenge against his father? He reversed his judgments. Two of them, of course. Right to privacy.
Not right to privacy, we reversed the ADM Jabalpur judgment in the emergency judgment we reversed. And his judgment on the constitutional validity of adultery. They had held that the provision for punishment for adultery, under which only a man could be punished for adultery, not the woman, was valid.
So how did you feel? Very happy that you were reversing your father's judgments, or sad?
You know, at the end of it, we all sit as judges, and it's another judgment. It's another judgment that you're reversing. I mean, you never really, but I'm sure even if you were alive when I reversed his judgment, he would have said, well, that's part of the process, you know. And, ultimately, you reverse a judgment not because that judgment was wrong necessarily when it was made. I'm not talking of a particular judgment. You reverse a judgment because it's no longer in keeping with the ethos of the times. Say in 1950 when the Constitution was made, would anybody have thought of this, that you could have fighter pilots who are women, that you could have submariners commanding, a submarine, a nuclear submarine who would be a woman? Because that was not our society then. I mean, this is the shared experience which you gain as society evolves, isn't it? So it's not just that you reverse a judgment because the judgment was wrong. All of us, when we reverse a judgment, you're conscious of the fact that the judge who wrote the judgment was tremendously distinguished. We reversed a judgment recently of Justice Krishna here. It says time's up, and that's the last point which I'll make. There's a provision of our constitution which says that the state shall so, direct its policies to secure that the material resources of the community are so distributed to best serve the common good. Now, Justice Krishna Iyer, in a judgment which he delivered, wrote that the individual is a part of the community, therefore everything that belongs to the individual is part of a material resource of the community. And we reversed that. We said some things which belong to an individual may be part of the material resources of the community, like say water, a segment of the river. Of course, the river can't be individual property in that sense. Or the airwaves, because this is a public resource. It has to be used for, it's part of the common good. But can you say that, somebody who's manufacturing cars, that's a resource? So you tell a car manufacturer that, look, what you're manufacturing is a part of the material resource of the community. Or a semiconductor manufacturer. You want to have a semiconductor manufacturer coming in from, say, Taiwan to manufacture semiconductor chips. And you tell him that this is a material resource of the community, he'll say, thank you, but I'll not invest in India. So, so the reason why we reversed that judgment was not because there was a fundamental error. Probably when Justice Krishna decided that socialism, the social welfare state, these were critical ideas which were animating the times. Today, as the market reforms have taken out, of course we are still a welfare state, but the whole discourse has shifted. And I dare say, 25 years down the line, the work which we have done as judges will be assessed by posterity to see whether it's in accordance with the ethos of that time as it will be at that time.
True. When I invited DYCJ, his only condition was that I should let him interact with the students. So I'll not break that promise. I have some names and the questions also. I would request the student to just stand up. I have the student's question too. I'll read it out. Yagenseni. Yeah. I'll read out your question. So she is asking, with increase of digitalization in the legal field, including virtual courtrooms and AI-assisted legal research, what are the biggest challenges and opportunities you foresee in Indian judiciary?
The greatest opportunity is that, technology has no known limit today. And technology is changing so rapidly. And it's going to change the face of the way we work as lawyers, as judges, as civil society. It's already changing that. Artificial intelligence has its own intelligence. It's not just human-driven. Artificial intelligence today can be an independent decision maker. So great opportunities which we have tried to tap within the Indian judiciary. But at the same time, some cause for concern and restraint that AI does have some inbuilt biases It's known to have racial profiling, some biases against women. Uh, would you also want AI to decide as to whether somebody should be sentenced to death, or would you rather leave it to an imperfect human decision maker? Maybe I'm conservative that when I say so, but I still trust a human being more to decide whether somebody should be granted the ultimate penalty of capital punishment.
That human touch should always be there on the law. Carolyn Nirmala, she's there, and her question is what reforms are needed to make the process of judicial appointments more transparent by maintaining judicial independence?
We've actually dealt with that question when we were in discussion, but I just want to focus on one small part, which is transparency. How much transparency should you have when you are making judicial appointments? At a certain level, you may say, well, society wants to know why you have made a particular judge a judge of the High Court. But too much transparency will actually prevent people from accepting judicial office. They'll say, but look, I have not bargained to put every little element in my life as an individual for public consumption. Because your personal relationships, somebody who's had a divorce, a woman who's had a divorce, or a man who's had a divorce, the collegium will, of course, apply their mind and see what the facts were. Would you want it to be put in the public realm for everybody and all and sundry to sort of, inquire into the individual personal aspects of their lives, a relationship, a failed relationship? So transparency can sometimes be self-defeating. So in our plea for transparency, we shouldn't be in a situation where good people wouldn't accept judgeship at all. That's my concern.
Harini, her question, sir, is how should law evolve to protect digital privacy in the age of artificial intelligence?
That's something which societies across the world, Harini, are debating. The European Union has come out with the global data protection regime. I'm not sure that's the perfect regime even now, or whether that's just work in progress. Because something that's happening now as a result of, the increasing electronic footprint, and particularly AI, every aspect of our lives is being watched by Big Brother. And Big Brother is not government. Big Brother is, some of the largest corporations on the AI front. Every time, you book a Uber, the time when you booked it, the place from where you went to which place you went, every time you book a meal in a restaurant, every aspect of your personal preferences is up for scrutiny. And that's what algorithms are all about. They are aggregating data. And therefore, in that sense, I'm doubtful whether there is any element of privacy left in the individual at all. How should societies balance the need for free information, such great benefits of the free flow of information, with these concerns? I don't think societies across the world have found a specific answer. Partly the reason is that technology is moving so rapidly that the law is much slower than technology in keeping pace.
Ram Shivanu, yes. What are the ethical concerns associated with granting intellectual property protection for works created by AI? And his second question is, how might this affect human creators and innovations?
Well, there are serious ethical concerns. For instance, if a poem is written by AI, right? AI you go to your cell phone and go to Meta and say, I'd like a poem on the theme of, a sea on a cloudy day, and they'll give you a poem in 3 minutes. Is it capable of being, IP protected, or a song? Or is protection something which was intrinsically meant for human intelligence? So the philosophical question really is AI today replicating human intelligence? And if human intelligence can be protected by intellectual property, why not artificial intelligence?
The last question from Arya AT. Yes. Arya, his question, sir, is, how do you perceive the evolution of traditional litigation practices in response to the growing dominance of corporate litigation?
I wouldn't call it you know, the dominance of corporate litigation, because even today across the civil courts, the high courts and the Supreme Court, corporate litigation doesn't dominate. The domination is by, if I can say that, the government, which is the largest single litigant, which brings cases to the court. And second, individual disputes which come to the court. What I strongly, however, feel is this, that very often you've seen that the processes of the court are used very often by largely resourced clients to delay or defeat justice. And therefore, we must, as a profession, as an institution, start awarding real-time costs. If a large corporate body has filed a PIL, for instance, for challenging, say, an expressway, or for the setting up of a greenfield project, an airport or a port, and that challenge fails, you have to pay for judicial time. Not in terms of the individual judge's time, this is a small pittance, the salaries which are paid to your courts, but the judicial time of the infrastructure. So many other cases which could not be heard. And I think we have to therefore discourage the use of litigative processes, particularly by largely resourced clients, to delay justice or defeat justice. Otherwise, today there is no disincentive to pursuing litigation just as an avoidance strategy.
So with this, we come to the end of this session.
Mr. N. Ram had a question.
So Mr. Ram has a question.
I read this book, Court on Trial, a data-driven account of the Supreme Court of India. It comes to several conclusions: short tenures, disproportionate power of senior advocates in the Supreme Court, particularly in admitting SLPs and so on. But my question, I'll confine it to one question. The disparity between the retirement ages of High Court judges and Supreme Court judges. We have heard, or at least these are impressions, that judges who fancy they have a good chance of making it to the Supreme Court and also avoid retirement at the age of 62 are somewhat inhibited in, let's say, in the assertion of their independence. They have to be very, very careful not to tread on the shores of, not to displease, somebody who has influence at the collegium and so on. These are impressions, may not be true. So why not do a simple thing, make it the same retirement age? There's also a case for raising the retirement age of judges as life expectancy at birth increases and so on. I'm not getting into that, but at least 65, would there not be a marked change in attitudes or impressions about the performance of High Court judges if they retire at the same age? There may not be an incentive then to go to the Supreme Court and therefore prolong their judicial career, apart from the greater recognition by going to the Supreme Court. Can Parliament simply enact a law making the retirement age the same, 65 or higher?
On the latter part of your question, it will have to be a constitutional amendment, because the age of retirement is constitutionally prescribed, so there has to be a constitutional amendment. But on the question itself, I couldn't agree with you more. I entirely agree with you that there is no justification for having one age of retirement for the high courts. That is to say that you are good enough to work in the high courts only until 62, but as a judge of the Supreme Court, you're good to work until 65. It doesn't make constitutional sense, nor in that sense conceptual clarity in that sense. Because, at a time when the age of retirement was fixed, originally the High Court judges retired at 60, by the way. 60 was increased sometime in the late 1960s to increase the age of retirement of High Court judges from 60 to 62. The Supreme Court has always been 65. What happens is this, that primarily the pool for appointment to the Supreme Courts is from the Chief Justices of the High Courts, though you have judges as well being appointed. Justice Joymalya Bakchi, who came in as a puisne judge of the Kolkata High Court to the Supreme Court, is a classical illustration. Or Justice Pardiwala has come in, Justice Manoj Mishra came in recently from Allahabad, Justice Pardiwala from Gujarat. So it's not invariable that only Chief Justices are appointed. You have judges of the High Court appointed to the Supreme Court also. But you would find that, because of the fact that you have
an additional 3 years as a judge of the Supreme Court. A lot of Chief Justices are keen in that sense to come to the Supreme Court because A, of the fact that you get an extension of tenure by 3 years. I dare say that if you make the age of retirement the same for High Courts and the Supreme Court, many Chief Justices would not be interested in coming to the Supreme Court at all. A, for the reason that the kind of status and perquisites and honor which you get in the High Courts in the states as a Chief Justice is very different from the work which you do as a judge of the Supreme Court. The work which you do as a judge of the Supreme Court is almost 99% judicial work. So, the qualities which are required for being a good Chief Justice of the High Court includes good judicial work, but good administrative qualities as well. As a judge of the Supreme Court, your qualities are really that of a judge. And if you have an age of retirement which is identical, that will ensure that you could be able to bring to the Supreme Court people who are truly excellent judges. Right now, because of this age disparity, very often you bring in Chief Justices to the Supreme Court only because you feel, well, that person is now the senior most judge. The moment the decision makers realize that, well, even if that person is not brought to the Supreme Court, they will continue for the same length of time. Those individuals themselves wouldn't be interested. Many of them may not be interested in coming to the Supreme Court, which you, for instance, found when people like Chief Justice Chagla, he declined higher judicial office. We've had other Chief Justices in the past who have declined to come to the Supreme Court. People like the Chief Justice P.D. Desai from Mumbai who didn't come to the Supreme Court. Chief Justice Chittadosh Mukherjee who retired from likewise. So I think there's a great deal of importance and substance in what you say, that there must be the same age of retirement for both High Court and Supreme Court judges, and perhaps a rethink about the overall cap on retirement as well.
Thank you very much, everyone.